Welcome to Torn, the only podcast committed to exposing the truth about the child welfare system and its devastating impact on families of color, told from the perspective of your hosts, Sonia Johnson and Classie Colinet, two defense attorneys who have over 15 years of experience working in the child welfare system.
So welcome everybody to another episode of Torn. I am joined here by my wonderful co-host, Sonia Johnson. And we also have the pleasure of having Dwight Miller, who is a fierce advocate in the field. Dwight, introduce yourself to our listeners before we dig into the episode.
My name is Dwight Miller. I practice in New Jersey for the most part. I've been doing CIC and family law for quite some time. I've actually been an attorney for about 30 years now. Doing the CIC for the last 10 or so. I did criminal before that and some other things, corporate. And I've been working with children in need in different capacities, whether it's socially or in the courts, for quite some time. It's a pleasure to be here, and thank you for having me.
Welcome, Dwight.
You.
And just for purposes of our listeners, I know you mentioned CIC. All of us who are here in the Garden State, we do know what you mean when you say CIC. We know you mean children in court. But
Yes.
For those who are listening to us who may not be familiar with that, that's the label that we give the cases that are in the child welfare system. Dwight, for those of us who are in the field, we know that reasonable efforts is often what we utilize in court when we are trying to explain what the Child Welfare Agency, also known as the Division of Child Protection and Permanency, has to do in each of our cases. And the goal, of course, behind reasonable efforts is to help preserve and reunify families before placing a child in foster care. And this is by preventing or eliminating the need for removal through supports and services. And then for those children who are ultimately removed from their home, reasonable efforts must be made to provide support and services that help promote reunification. Now, Dwight, since you have such a significant amount of experience in the field, can you tell us what your view is of reasonable efforts and how it looks in real life in the courtroom?
My view of reasonable efforts is that it's something that is truly not defined. There's nothing that you can go to, whether it's a case or the statute, that says this is exactly what reasonable efforts means. So when you hear a court say something to the effect of reasonable efforts have been made in this case, they usually don't tie it into the goal of reasonable efforts, right? So we'll hear a judge often say, well, and we'll hear someone from DCP&P usually, they'll state, we did this, we did that, we did this. We gave them some drug treatment programs, we did family counseling, we did anger management. However, they never connected to the goal. And as you stated before, according to the statute, the goal is twofold. If the child is inside the home, it is to make sure and ensure that they do every effort so that the child will not be removed from the home. If the child is outside of the home in placement, they're supposed to make every effort to make sure that the child will be reunified with the birth parents or the legal guardians. Now, oftentimes what we hear is, I call it cookie cutter, I would say recommendations. It may not fit the actual person. So when they say a person needs, for example, family counseling or family therapy, why? What issue are you going to deal with that's a part of this case? What issue are you going to deal with that is going to make sure that the child is not harmed in any way or potentially harmed? So when you have someone speaking about reasonable effort, what I would always do is tie it into the goal of reasonable efforts. So when a court would say to an individual or on the record, the person is found, we find that the DCP&P has did all reasonable efforts. And I will say, what does that mean, Judge? Explain that to us so that we'll understand. Reasonable efforts for what? Are you saying that the person just needs some drug treatment? But what is the goal? And they often don't tie it in. So when there's a definition, you kind of have to go to the case law for some types of definition of reasonable efforts. And there's several cases that dealt with certain things like poverty and what reasonable efforts looks like, sibling visitation and what reasonable efforts looks like. But there's no codified, nothing in the code that states this is what reasonable effort is. And as a result of that, oftentimes any effort, no matter how minuscule, will be put before the court, and the court will say it's reasonable. And I'm sorry, I can't give a better definition of that, because it would be on a case by case basis, using case law to analyze the actual situation and the facts of the case.
Dwight, I think you just nailed it. I mean, when you said that the term is not defined anywhere, and certainly when I started doing this work, reasonable efforts, it's like, well, what does that mean? And Classie and I, on a previous podcast, I think, talked about the fact that the term is almost like with all deliberate speed. Like, and we know how that has historically been used in history. Like, with all deliberate speed had no impact, had no effect, because it didn't happen. And I think reasonable efforts is kind of along the same vein in terms of it is an ambiguous phrase. And I think it's kept ambiguous for a reason, so that, anything can be argued that it is a reasonable effort on the behalf of the state. I know when I first started doing this work, and I remember standing in court at my first permanency hearing and reading the recitation of what the division set forth as their reasonable efforts. And I was shocked, because it included things like board rate for foster care. It included things like, bonding evaluations, psychological evaluations, substance abuse services, parenting classes. I'm like, really? That's what reasonable efforts is? And so I'm wondering, in your experience, have you kind of felt the same thing or seen the same thing?
I must say I have. It would be anything, and because it's not defined and because it's a bit nebulous, it could be anything that they said that they did. Actually, it could be a phone call to a provider. Reasonable efforts. Now, they didn't set up the provider, whether it's drugs, whether it's alcohol, whether it's parenting classes. They didn't actually set it up, but they made the phone call. And when you look in their court report, they'll have that as part of their reasonable efforts. And you're like, well, that's what you're supposed to do. These are some basics that you're supposed to do. And I don't know if that really takes any effort if you're doing what you're basically supposed to do. And you and I, we know that you will have a client that has been sitting for 6 months waiting to get into a program. And every time someone from the division comes to court, what will they say? They'll say, well, we've called the program and they're still on a waiting list. And some judges will say that's reasonable efforts. Now, think about this. You have a child outside of the home. The only thing that is separating the child from rejoining their parents is a drug treatment program. And your client has been waiting for 6 months because they say, well, your client speaks, let's go, Swahili. And we can't in any way find a program that has a Swahili translation or translator. But your client in that 6 months has been clean, been successful in all of his urinalysis, obtained a job. However, the one goal that he has is in the division's hand. And that's a whole nother story that I have. When I first came to CIC, children in court work, being in other fields, it felt so alien because it's the only lawsuit that the plaintiff gets to monitor the defendant and use the things in court that they've monitored the defendant for against the defendant. That was the strangest thing I came across. And when they say, okay, and I look at it like this, it's a lawsuit, right? There's a plaintiff and there's a defendant. The plaintiff wants to win. Don't forget that it's a lawsuit. The plaintiff
Right.
wants to win. So the plaintiff is going to do everything they can to win. And that means sometimes obstructing the progress of your client.
Mm.
And they do it all the time. They write something up and they have to do everything they can to prove this because they're the plaintiff. And when you're in CIC, children in court for a long time, and you started there and you haven't come from a different area of practicing law, you just see that as normal. Whereas I thought that was something very foreign. I've dealt with a system in Minnesota, in Minneapolis, and they have a system that is somewhat a little more progressive than ours because all of their resources come from what we consider the public defender's office. For example, they have a liaison in the office that tries to set up all of the counseling. They have a liaison in the office that tries to set up the parenting time. They have a liaison that sets up any type of psychological testing that they need, and they do it themselves, and they present it to the court. I mean, now, can you imagine if we had it like that?
It would be such a shift. And like you, I come to this work having done other things. I was a litigation associate for a firm in Boston for a while. I was a prosecutor in Massachusetts for a while. And so I've practiced in other areas. And like you, my mind was blown when I saw that the plaintiff has all the power, all the resources, gets to run the plays, has access to all the service providers that our clients are supposed to form therapeutic relationships with, can reach out to that therapeutic provider and ask questions about our client's progress. And then they want to come in court and use all of that arsenal against our clients and call it a fair fight. That's insane. And if we had something like, you said it was Minnesota?
Yes, it's in Minneapolis, actually.
Minneapolis. That would change the game 100%. 100%.
But even in terms of basic fairness, how in the world is an organization like DCP&P going to get a psychological evaluation not only before the defense attorney, but before the client?
But here's the thing about the psychological. The client goes to the psychologist and shares their entire story. The report belongs to the division. The report does not belong to the client.
Absolutely.
That blew my mind.
And I'm still shocked by that. I'm still shocked that with all the things that people will say in their psychological, with all of the supposed honoring of HIPAA, that it's allowed that a worker who probably has no background in medical, psychological, psychiatric, they get a report and they make a recommendation based on this report to the judge, sometimes before your client or my client has even read the report. We have to call them often and say, hey, did you get the report yet? Has the report come back yet? And sometimes they give it to us, and sometimes they try to wait to the last minute, which is often. And now we have to go through the whole thing of, okay, do I need to hire our own expert? Well, we should be doing that from the beginning. And I understand that that particular office doesn't have the resources, maybe, but there has to be something done for that, because like you said, it makes like a boxing match with the heavyweight champion and a amateur with one arm. That's how unfair it is. How can you begin your defense, and I'll say defense, when everything that you're supposed to have, you have to get from them? And they don't have to give you, like in criminal, you have to get Brady material. Sometimes they may not give it to you, but there's repercussions if they don't. The division doesn't have to turn over anything that is in any way favorable to your client. They don't have to do it by statute, by case law. They don't have to do that at all. So they can put up in front of the court, and of course, that's why it's very important to go look at their file, but they can put up in front of the court, at whether it's a summary hearing or a trial, everything negative about your client that they had for maybe 2 years. And they can bury everything that's positive. And if they do, and you don't find it, your client is the one who loses out. And there's nothing that you can do after the case when you do find it. I mean, there's reconsiderations and other things, but then it's pretty much too late. So the system, as it is right now, my opinion is that it needs to be overhauled from the beginning, from scratch. It truly needs to be overhauled, because what I see is my perception is different. My perception comes with my background and my history. So I start seeing, when certain things are done, people on the auction block and children being ripped out of people's arms. I start seeing what they would call the reprehensibles during the eugenics era in the United States.
Right.
Right. Those are the things that I see. And when we're dealing with things that are undefined, like reasonable efforts, well, you can get away with those things.
Dwight, since, as you already said, reasonable efforts is not, there's no clear definition of it in the state of New Jersey. So could you tell our listeners a little bit about what, if any, trends or common practices you notice with respect to how the Child Welfare Agency implemented these so-called reasonable efforts in cases that involved Black families versus cases that involved white families?
Well, the hurdles for Black families, and this is my personal opinion, and it doesn't reflect on your show at all, but what I've seen is that the hurdles for Black families are much higher. The things in which they want African American families to do is usually at least twice as much as other people, other non-melanated people. And
could you give us some examples, Dwight?
Sure, I'll give an example. And this is an example I've used before when we're dealing with poverty. And there was a particular judge and a particular DAG. They were saying that my clients were poor. And as a result of them being poor and not having enough space, they wanted to remove children from the home, my clients. And the clients had a house that had 3 bedrooms. There was a mother and a father. There were 3 children, 3 girls and 3 boys. 3 girls stayed in one room, 3 boys stayed in another room. The parents stayed in like a kind of a small room that probably was something else, but they converted into a bedroom. So 3 bedrooms. And they were an African American family. And what I tell people oftentimes is that the division, they stifle the ability to have those Horatio Alger stories where people rise up from being poor and conquer things and become great people in the United States. And how do they do that? They were saying that because my client could not get a better place or a bigger place to live because they could not afford it, then some of the children should be removed. That was it, poverty, nothing else. Wow. And of course, these people were African American. African American. Now, do I say that they would never do that with people who were non-melanated or considered white people? Well, I haven't seen it. Now, you have a home, you have 2 parents in the home. However, the parents are lower class as far as economics are concerned. Spiritually, they're probably upper class compared to many, right? So they're arguing to the judge about how basically these children should be taken out the home. It's too many people, it's overcrowding, it's this is in a bad neighborhood, and so forth and so on. So the judge, who's older, and I say at least my age, we have certain things that we grew up with. And something that we grew up with on television when I was younger was the Brady Bunch. And I looked at the judge and I said, Judge, I'm going to ask a question, and it's kind of rhetorical. if you have 3 boys in one room, children, and 3 girls in another room, and 2 parents in another room, what do you call that? And the DIG blurted out, well, that's terrible. That's poverty. I said, Judge, when I grew up, that was called the Brady Bunch. They were America's family at that time.
Right.
No, I mean, there came a time after that where everyone wanted the individual rooms, but no one was thinking about the individual room. And this was supposed to be the perfect blended, mind you, American family. Now, the judge actually smiled because she remembered. And she said, yes, I don't understand, but I could not see that happening to anyone who wasn't Black. I couldn't see that happening to a couple that's not Black, a white couple. I couldn't see that happening. And I've seen reasonable efforts. I've seen them take away children from African American families because of drug use. Not drug abuse, drug use, sometimes drug misuse. And I've seen them have the same type, and I brought this up in court before. I've actually used 2 cases to show the court how they were being treated before. I've seen a white family with the same issue, and guess what they did? They're going to monitor them. We're going to monitor. We're going to give them more monitoring. We're going to have somebody come over to their house and stay with them. Never even mentioned that in the case where there were people of color. So these are the efforts that they're making, all right. They're saying, okay, well, you have to do these things. And not saying that they didn't tell the white family that they have to have, they shouldn't have any type of rehabilitation when it comes to CDS drugs. They did, but the implementation of it was not correct. And it's never been correct from what I've seen. And I'm sure there were people that will argue and say, yes, it's a fair system and it's correct. No, it's really not. And that ties into a lot of things with the way that CIC court is run. That is, one, it's a closed hearing.
Right.
Closed. So on the record, only
Dwight,
I'm
before
sorry.
you dig deep into closed hearings, can you tell our listeners what you mean when you say closed hearings? Because they may not know what that means.
Oh, thank you. Legal proceedings in front of a court, they're open to the public. That is, the public can sit down in there, they can listen, they can take notes, they can stay as long as they want during any type of case, except CIC cases and I believe domestic abuse cases. So, and even in domestic abuse cases, they'll have all of the victims in the court at the same time. So I'm not too sure about that. In CIC cases, people of the public, the press, you can't come in. It's a closed hearing. That is you, your client, the plaintiff and the plaintiff side, the judge, and pretty much that's it, if you not including the sheriff's officers. So no one gets to see what actually goes on inside these courts. And that is another reason why we often hear in CIC court judges that will make a ruling with very little law.
Right. Right.
So they'll say, I think, they'll say, I feel like. And when you ask them where in the law gives you the right to do that, oftentimes they can't give an answer. Well, you can appeal me. Now, no one else would say that in the open court. Open court, I rarely ever heard anyone say, well, you can appeal me. I've heard people say, well, if you want to, we can talk about it later on, or we submit something to the court, Mr. Miller. But just the boldness of looking at you, say, well, you can appeal me.
Right. Right. Dwight, we talked about that reasonable efforts is not defined. And I am struck when I was looking at reasonable efforts and like you trying to define it so that, when I make an argument that the division has not provided reasonable efforts, I can look to something. And I remember looking that up and not being able to find anything. But I do know that I came across this term active efforts within the context of ICWA, which is the Indian Child Welfare Act. And so that our listeners know that the ICWA is a federal law that requires the division to employ active efforts when the child that is the subject of litigation is a federally recognized American Indian child or parentage, has parentage, federal American Indian parentage. And so I looked up the definition of active efforts, and I thought, well, that sounds more like what we kind of need in child welfare. And I'm just struck that there is this distinction, and I understand why we have it because of the devastation of the Native Americans in this country. But we as African Americans, don't we have a similar history in terms of the destruction of our families? And wouldn't you think that active efforts would be a more appropriate term within the context of child welfare, looking at things from a reparative justice standpoint?
I do, but I also think that with active efforts, you have to also believe, and many people don't, that there is a tradition of healing and helping for people. That is their own tradition. So when we have a people like the Native Americans who have their own traditions and their own healing systems, and you have a Native child, the court has pretty much said, well, we're going to do all that we can to heal them and acknowledge their traditions for this child because they recognize their traditions. Now, our traditions aren't really recognized. So it is very difficult for other people to say to us, we're going to look at it in this way. And that brings up something that is missing from our system: post-traumatic slave syndrome.
Speak on it.
Tell me, have you ever seen a psychologist, psychiatrist from the division ever mention this? And one of the issues with post-traumatic slave syndrome is that people often think about the things that they're going to do before they do it. Right? And I say this in a broad sense. For example, we don't have the luxury of saying, I'm going to go to this particular place for vacation without saying, I wonder how we're going to be treated there.
Right. Dwight, just to back you up, can you just explain what the post-traumatic slave syndrome is for our listeners?
Sure. It is vestiges of slavery that have inculcated our lives presently, so that we, of course, those things that, especially trauma, generationally, have forced us to act and think in a certain way for our own defense. Right? For our own defense. Like I just mentioned, we want to go on vacation and we have the money to go on vacation, but we have to say, oh, I'm not too sure about this particular area.
Right.
If I want to get on I-70 or I-40 and drive from New Jersey to California, I have to worry about where I'm going to stop at night still.
Exactly.
Right? Other people don't have to worry about that. But it also dictates how we come to court and how sometimes we may seem a little angry. It also dictates how we don't believe in the system.
Right.
How we believe that the system is some way and oftentimes rigged against us.
Right.
And none of the psychologists I've seen in the last 30 years, there was one gentleman, but he no longer works in New Jersey, and that was years ago, even looks at this because, first of all, they don't acknowledge our tradition, our suffering, our pain. They don't acknowledge our own healing systems, which could be sometimes grandma.
Right.
When I was a young kid in elementary school, they would have grandmothers come to the school and sit in classes with us. Maybe not our grandmothers, but we called them grandma. Why? Because they gave us comfort. They gave us warmth. We understood that they were the backbone of our society. We understood that no matter what was going on and how hard and what type of oppression they did with our men in our communities, we had our grandmothers. That's a healing system for us. and they don't recognize those things. So when we're talking about active efforts, bringing it back, if they don't recognize our traditions and our own healing systems, then they're not going to use the same things that they're going to use for the natives.
Right, right. It's a good point. Dr. I think it's Joy DeGruy wrote the book on post-traumatic slave syndrome. And so I know that there's a lot on social media about that. A lot of people are beginning to talk about it in circles, but outside of child welfare. It hasn't really permeated child welfare as much. But certainly Classie and we've tried to highlight the importance of cultural competence, particularly around psychological evaluations. And that is really just scratching the surface, because even when you have a culturally competent psychologist, they may or may not be familiar with the term post-traumatic slave syndrome and the impact. They just know that clients are showing up a certain way based upon the experiences that they have experienced while being people of color in this country.
Sure. When we're talking about efforts and we're dealing with psychologists and psychiatrists, and you introduce yourself in a certain way, they've already made an opinion about you. And you can see it in all the evaluations. And oftentimes when the state tells us to do something, historically, it has never been something that's going to end up favorable for us.
Mm.
They say this is for your own good. No, more likely than not, that is not. And so we have a history of that. We have a history of being, I'm going to say, bamboozled with different systems, whether it's medical treatment, whether it's the welfare system. We've been bamboozled. And then when we go through these things, we realize that we made a mistake. And we've learned from that. So now when the state says to us, this is for your own good, well, you haven't walked in our shoes. You don't know where we live. We don't know where you come from. You don't speak our language. I mean, we speak English. However, our language is our language of compassion, our language of love, our language of community. You don't speak those languages, and you live in a place where you don't know your neighbors. You live in the suburbs, which is a beautiful thing. You've lived there for 10 years, and you don't know the people 2 doors down from you. You don't know their names. You don't know. You might see their kids get on the school bus. That's not where we come from. So if you don't know those things, how are you going to implement those things that are best for us?
Right.
And just I'll give another quick story. I had a client who was South Asian, and their basic daily belief system was that if you go to their house, in order for you to get into their house or for them to go in the house, you have to take off your shoes. The division worker came in, no cultural sensitivity, no cultural training, put on the record how this person refused to allow them to go into your home, to their home.
Wow.
Oh, you can't come in my house. No, you can't. That's all. She wouldn't allow me to come in. I couldn't go in. I couldn't see what was going on in the house. So I talked to my client. I'm like, well, what happened? And she said, quite frankly, I told her that she can come in my house. She just has to take off her shoes.
Wow.
How simple is that? However, if you look at the report, it's refusal after refusal after refusal not to allow this person. My client did not allow this person to the home. No cultural sensitivity. So when I pointed that out to the judge, this judge actually understood and said, listen, take off their shoes. Will you allow them in the house? Absolutely. But this had been going on every time they had gone. They had reported that wasn't allowed to go in the house. Wasn't allowed to go in the house.
Wow.
So no cultural sensitivity, no cultural awareness whatsoever. And I doubt they're actually trained in any type of cultural awareness, because I've seen it over and over again with different cultures.
So that just cuts against the whole reasonable efforts, because if you can't meet me, at least on a basic human level, and understand and appreciate my cultural sensitivities when you're coming into my space, then there is no meeting of the minds. And if there's no meeting of the minds, you can't have a reasonable working team atmosphere or environment for there to be reasonable efforts. And I think that is so often lost, when we as defense attorneys are standing up making the argument that no, there haven't been reasonable efforts here because there's never been a meeting of the minds between the client and the caseworker.
And if you don't respect someone's culture and history, are you truly going to give or make an effort?
Right. Right. Dwight, I had one last question. We know the system that we currently have. What would you like to see in terms of an improvement, particularly in the area around reasonable efforts?
I would like to see, practically speaking, I would like to see the case law used much more. I don't believe that the case law is actually used, especially when we're dealing with poverty. I would also like to see someone being able to, and of course, this is just my wish list, of course, someone outside of the agency, a third party, if possible, set up those programs and resources that are needed for my client. And oftentimes, when you're dealing with a client that is going through what our clients go through, and they're a little upset, and I understand that the division workers are only human, but they take a lot of things personally. And as a result, because there's no buffer in between them, they write the worst things and they don't do the things that they need to do to actually help the client because they have some misgivings about your client.
Right.
Personally, I've had people call me up, DAG, say, well, your client just cursed her out. I'm like, well, why? Well, because you came to that person's house and you dealt with them in such a condescending nature that they had to respond to you in a way in which would get your attention.
Right.
So I think that would help quite a bit. But I also think, most importantly, that the judges have to, and I'm not saying that the judges are unfair. Some of them are very fair, but they have to treat the plaintiff just like they treat the defendant. For example, when there's reasonable efforts with my client and my client misses an appointment, the judges oftentimes are very hard on my client. When the division fails to set up that appointment and we get back to court, this is why we need a third party doing these things. I wasn't able to do it, Judge. They're on a waiting list. I called and no one answered. They don't get the same type of legal lashing from the court that our clients get. And I always tell people the most important people besides the children are the parents, because they're the ones with the constitutional right to raise children. Their rights are being infringed upon at this time. So if we don't look at it like that, and the division gets up there and they say all types of things, and oftentimes they're giving the benefit of the doubt if they make a mistake. Right. Where our clients, they just don't give them the benefit of the doubt. But in a fair system where there's a plaintiff and a defendant, and we're not even talking about criminal where there's a presumption of innocence, at least, right? Here we're always trying to disprove what the division had to say about our client. It's not put up in front of the court as, and I make the argument all the time, Judge, these are merely allegations. However, oftentimes the judges take what they say as truth. And I understand that. And how do I understand it? Because I understand how they see our clients. They're marginal peoples. They're people that oftentimes can't afford an attorney. They can't afford to go get their own psychological. They can't afford sometimes even rise to the courthouse. And they're looked at as marginal. And as a result of that, it's an eye of them. The court often looks at them as them. And they look at the people from the division as us.
Yes, thank you, Dwight. Dwight, we always close out each episode with tips for our listeners. And Dwight, you did cover a good amount of ground, and we want to thank you for that. As we close out, do you have any tips that you would give to a parent or a family who is in a child welfare case and is dealing with many of the issues that you've raised, in addition to this vague and ambiguous term, reasonable efforts?
yes, regarding reasonable efforts, I would suggest that families who are dealing with the system, CIC system, and the division, advise their attorneys as soon as possible of all of their social needs. It's very important that they tell their attorneys what their social needs are, whether it be rent, power bills, whether they need some type of treatment. Tell your attorney. And I'm just going to take a second on why that's important. Because we know what is going to come down the pike. And we're going to understand what efforts need to be made so that these social needs will be taken care of. Now, what I often do is that when they do that, I write a letter to the DAG saying, these are the things that my client needs. I contact the division through the DAG, say, these are the things that my client needs. And we need to address these as soon as possible because I'm all about reunification. Now, if they try to address them, okay, well, fine, but oftentimes they don't. So what I want them to do is identify the resources for my client that is going to directly affect and take care of the needs in which they have. And if they can't do that, then I file a motion. And this is why it's very important that the client and the attorney work together. You file a motion on behalf of your client requesting reasonable efforts. It's that simple. When in fact they're not doing anything and you've already given them a list of all the things that you need, now you have it documented. This is what my client needs. This is what my client says he or she needs. And they don't do it. Well, now you can go in front of the judge and say, listen, judge, this is what I sent. They haven't addressed any of those things. And what we're talking about, what the goal is to keep families united or reunify families. And the longer they don't deal with these things, the longer we're going to have to deal with these things, Judge. So I'm asking for order to make sure that we go through this list, and I give the judge the same list. We go through this list and say, these are things that we need so that my client can be whole. And the children and the family can be unified. So
wow, yeah, that's excellent. Any other tips? We always try to end with at least 3 tips. So I know you just went over 1. Do you have maybe 2 more you can think of?
I do. Don't be afraid at all to advocate for your client. We've come into a time in which attorneys that I speak with who see myself and you in court, and they just say, I don't know why you do that. You're making the judge upset. Well, when I was, as I mentioned, I may be a little older than you are. That's our job. Our job is to sometimes shake up the court so that they can see, even if they're upset, that what they're doing may be incorrect. And sometimes it takes a person that is going to forcefully represent their client. We just can't. We want to all get along, but sometimes we just can't. And when we can't, we have to make sure that we are protecting the interests of our client. It has come to my attention that there have been some attorneys who will talk with the DAG and try to work out something with their client, for their client, without their client's knowledge. Well, another tip that I say, and I tell my clients, I say, you and I, outside of court, may fight like cats and dogs. We may not get along. We may yell at each other. I may not understand where you're coming from. You may not understand what I'm coming from. However, in front of everyone else, I don't care who it is, we are a united front. In front of everyone else, I don't let anyone bash my client. It drives me crazy when I hear a DAG talk to a defense attorney and be like, well, your client is such and such and such. And the person just shakes their head. No, if you say that to me, then there's going to be a fight. Right? There's going to be a fight. Why? Because my client is the one that's going through things. My client is the one that's losing his or her hair over this. My client is the one that's not sleeping. My client's up worrying. When we leave there, for the most part, we're going to go home to our comfortable homes, our wonderful families, and don't have these issues. So when we're there, we have to fight so that everyone can have the same type of comfort and luxury with their families that we do. And most importantly, that everyone enjoys the same rights. Now, we're supposed to all have the same right, but it's not only race, but it's economics too. And to end this, I have a very close friend of mine. And of course, I'm not going to say his name, but he is an attorney. And he lives in a very upper class neighborhood. And his son, which was 15 years old, overdosed on drugs. He lived. He took his son to the hospital. He called me. He said, listen, more likely than not, from what you tell me, I'm going to get a call from DCP&P. What do I do? What do I say? And I must also mention that he's white. And I said, okay, this is what you do. This is what you say. 2 weeks went by. He just called me because we talked. Didn't mention. I said, well, what happened with the DCP&P? They never came to my house.
Wow.
I mean, he lives in an affluent neighborhood.
Yep.
They never came to my house. I said, what do you mean they never came to your house? You went to the hospital. Yes. They did a report. Yes. Anybody? Nothing. Not a call, not a phone, nothing. So it starts at the bottom. It starts with the reporting. It starts where they look and see the demographic, where you're from, what you probably look like, how much money you make, and then they decide. And this is where I say it's all connected to eugenics, to me. The reprehensibles, as they would quote unquote be called, DCP&P for the same issue would be there yesterday. For those people who they believe that are the pillars of society, who look a certain way, who have a certain job, who live in a certain neighborhood, we're going to let them handle that themselves.
I mean, you said a mouthful, Dwight. You said a mouthful, and thank you for that. I mean, that's what we've been trying to highlight with this podcast, that it is not about the welfare of children. It is about policing certain families within the community, and those families are Black and brown families. So thank you for those excellent tips. I had my pen out. I was jotting down notes. I really like the ask your client what they need up front and put it in writing. So at that permanency hearing, you can be like, well, this is what I said my client needed, Judge. We don't have any of these things.
Absolutely.
I love that. Thank you so very much, Dwight.
Yes.
Thank you so much. I appreciate it. And keep fighting the good fight.
Thank you. Will do. Thank you, Dwight, for being a great social engineer. As Charles Hamilton Houston said, a lawyer is either a parasite on society or a social engineer. So keep doing what you're doing, and thank you for your time.
And views expressed on this podcast are those of its hosts and guests and represent our own lived experience. The views and opinions expressed do not reflect those of any agency or organization with which we may be associated.